One of the biggest mistakes I see employers make related to their employment agreements is the failure to have one or the failure to introduce one into their business. And a lot of the times, employers tell me it's because they don't think they're enforceable in Kansas, that Kansas courts don't enforce non-competes, so they're a waste of time, but that's simply just not the case. In Kansas, non-competes and restricted covenants like non-competes are absolutely enforceable. The laws on that vary from state to state, so it's important to consider what non-competes you're using and what your non-compete looks like if you have businesses in Kansas and outside of Kansas. But within Kansas, non-competes and restrictive covenants like that are enforceable, and oftentimes employers are failing to use that resource or that ability to protect their interests simply because they don't think they can. What we run into a lot with employers when they come in and they have an employee that's violating their non-compete, and one of the first questions I ask is, how have you enforced these non-competes in the past? And a mistake lots and lots of employers make is they try to decide which non-compete situations they should enforce and which ones they shouldn't. And the truth is that can really render your non-compete provision meaningless if you're not applying it consistently across all of your employees. So what we advise our employers to do, and what I say a lot, is make me the bad guy. Make me the one that reaches out to your employees that no longer work for you anymore and explain to them the existence of their non-compete, explain that to their new employer, and really work through the ways that they need to be in compliance with that. Because a failure to apply these provisions consistently can make a court really question whether or not you're trying to protect your interests or whether you're just trying to pick on employees that have left your business. Another mistake I see employers make with their non-competes is that they try to go too far for too long. So for an example, a lifetime 300-mile non-compete provision is simply not going to be enforced by Kansas courts. What they tend to look at is whether or not the non-compete provision that they've put into the employment agreement is reasonable. The courts want to make sure that we're not keeping employees from being able to do the job they're trained to do in the entire state forever. So when we're drafting employment agreements and when we're looking at your industry, we want to make sure we're using time and geographical scope limits that make sense for your employees and that make sense for your business. Another mistake I run into that employers make a lot is they fail to consider alternative options or different covenants in their non-competes that they may be able to use to protect their interests. So sometimes a non-compete gets the job done, but in other times a non-compete's not appropriate, or you can add other provisions that really bulk up the strength of your employment agreement. So for example, you could add a non-solicitation provision that keeps employees who no longer work for you from reaching out to your customers or reaching out to the employees that still work for you. Or you can add confidentiality provisions that require them to keep your information and your data private and confidential even after they leave your business. So working with an attorney at Martin Pringle will allow you to analyze whether or not some of those different kind of provisions are appropriate for your industry or appropriate for your employees. And some employees may need a non-compete and a non-solicitation, and other employees may just need a non-solicitation provision. So it really is a case-by-case analysis that's important to do. I often run into employers trying to use this one-size-fits-all approach for their businesses, and that can create problems just from the outset. You know, a lot of the times, even our most sophisticated clients, they try to use a non-compete from one industry and then pick it up, copy and paste it, change the name, and use it in another industry. And sometimes that can create problems that renders these provisions unenforceable. When it comes to non-competes, what's important to consider is that each industry is different, and each non-compete as applied to that industry needs to be considered differently. So getting on Google and searching for a non-compete and using the one that you find usually isn't your best option, because you may end up having a non-compete from Florida that is unenforceable in Kansas. So the best thing that you can do is tailor your non-compete specific to your industry, and that's something that we do regularly at Martin Pringle. We look at your industry and we look at what provisions are best for you. You know, another thing employers should consider when they're thinking about their non-competes is if they're at a point or have been at a point where they have merged or sold their assets or have bought another company, those non-compete provisions and contracts, those employment agreements, are assets, and they need to be considered in the buy-sell agreement between the buyer and the seller, so that when it comes time to enforce them, the company that has either been purchased or is purchasing can enforce those agreements. Another thing we often advise our employer clients to do if they've recently obtained new employees through something like that is having someone sign new non-competes with the new business name or the new entity. But those are often forgotten and can wind up with an employer in an uncomfortable situation.